In the pop culture world, Britney Spears and her guardianship case has become headlines, everyday talk. Today, I thought that we would switch course here from our normal set of interviews and go to an expert. I welcome Kim Browning. She runs Great Lakes Family Probate and Estates to give us some insight. Kim, welcome.
Hi, Jay. Thank you. It's great to be here.
Well, it's a pleasure to have you. So, Kim, why don't we talk about you for a few moments? I know that you may be uncomfortable, but I generally like to provide some background about you. So, you're an attorney, and you have a number of different areas of expertise. What are some of just a few of them?
Sure, Jay. I practice primarily in estate planning. I also practice in elder law and special needs planning, probate, and probate litigation. So probate is kind of a large umbrella, but it does deal with guardianships, conservatorships, litigation regarding wills, will contests.
Generally speaking, for families without a special needs situation or a guardianship situation, for the everyday viewer, listener, how early is it that someone should be considering, deploying an attorney with your background?
Well, that's a very good question. Honestly, many people put off coming to see an estate planning attorney for many reasons. One of them is they think that if they put their estate plan together, it might be jinxing them, right? Or some people avoid coming to an attorney because they believe they have to have a large estate. And that's really a primary reason that people stay away. But really, what people don't understand is you're not just going to an estate planning attorney to protect wealth and to make sure that your wealth is passed on to the people that you decide you want to receive that, but it's also incapacity planning. People don't prepare for incapacity. And a large percentage of our population that become incapacitated, that need to be under a guardianship, are younger people that have sudden medical experiences or automobile accidents, closed head injuries, and without putting powers of attorney in place, an individual is then forced into the court.
Generally speaking, and you're located in Detroit, is that right? So and I know this, but for our viewing audience, you're located in Detroit. Do the rules change much from state to state?
Well, yes. That's one of the misconceptions, especially with the Britney Spears case that's happening right now, is people think guardianship laws are the same across the country, but they're not. Guardianship laws are governed by each state. So what we have in Michigan is different than what there is in California. So for instance, taking the Britney Spears case, she has her father, who's her guardian, in charge of her personal decisions, her medical decisions, as well as managing her business affairs and her finances. In Michigan, our system is different. Our guardians are in charge of having legal authority over the individual's care, custody, and control. That means a legal guardian chooses where an individual is to live, which doctors they're to go see, and the medications that they take. They also can control the day-to-day activities that individual has and their training. If they're going to pursue a vocation, vocational training, or if they're going to continue with education, that's what the guardian controls. But in Michigan, we don't have the guardian control multi-million-dollar estates like Britney Spears. We have a conservatorship that's appointed, and the conservator then manages the business and finances of the individual. Now, sometimes the conservator and the guardian can be the same people, but it's not required.
So you dove quite deep into the weeds, Kim. So if we back up just a couple of steps, why don't you describe, since we're diving straight into it, Britney Spears case specifically, of course, lots of headlines. Britney Spears been, a figure in pop culture and pop music for, decades at this point. But what are some of the basic facts of what have gone on for those people who have not kept up to date?
Well, actually, as far as the Britney Spears case goes, what happened is she's been under guardianship for approximately 18 years. And it happened subsequent to a mental breakdown. And I believe an emergency guardian was put in place, and then another hearing took place, and then a permanent guardian was appointed.
Was it appointed by the court based on somebody's motion, or how does that happen? Or would that in theory happen? That's just the normal course of business that a judge would decide this, or somebody would have to actually file to try to become that, put in that position?
Right. So I'm going to speak about Michigan law because this is where I'm licensed. But in Michigan, an individual who is interested in the person's well-being can file a petition in the probate court in which that individual who's to be protected resides. And in that petition, there needs to be specific information provided, and a physician's statement actually is something that should be attached to it that details why that individual needs a guardian and specifically what their mental deficiencies are. And once that petition is filed, the individual who's going to be under the guardianship must be personally served this petition. So they are aware of it, along with the notice of hearing, because a hearing absolutely must be held. A guardianship does strip away, very important constitutional rights. So the probate courts do take that very seriously. And the level of proof that must be demonstrated in the hearing and leading up to the hearing is clear and convincing evidence that that individual needs a guardian.
I see. And so when they have a guardian and a guardian is appointed in Michigan, something that where you practice, is that for every aspect, meaning their financial and their health decisions as well? Why don't you give us a little bit more detail about, what that would entail, or how that definition is defined more specifically in Michigan?
Sure. So there isn't a bright line rule as to when a conservator needs to be appointed to manage the estate. Okay.
So yes, I've screwed up the terms, which is, what, non-legal persons would, are, I'm sure very, very apt to do. So conservatorship there is really to preserve asset quality, etc. But who's to make the other? I mean, you had mentioned other locations where even their vocation, what their daily activities are like. Is that the same degree here, or do I have it totally confused?
You don't have it totally confused. And I think what we need to clarify is the people who are under guardianships, okay? That is one of the misconceptions and misideas about what a guardianship is and who it's for. So first, we have guardianships generally for elderly people who have dementia, people who have experienced a stroke and can no longer make, informed decisions for themselves. So family members are going to petition to make the decisions for the appointment of guardian for them. Then you have developmentally disabled individuals. So you have people who have grown up, mentally disabled people, with Down syndrome or, other ailments. And those individuals, if they don't have the mental capacity to put together a power of attorney or patient advocate to appoint a person to make medical decisions for them, then a guardian must be appointed at age 18. So that guardian at age 18 then will make sure that that individual is in a group home or in a safe setting, and then help with choosing vocational activities and where a person actually works. Some people can work. So that's what the guardian does in those situations. And then we have this other group that, people don't understand, that we talked about a little bit. 34% of guardianships in this state are for people who are under the age of 60 who have mental illness or sudden mental incapacity caused by, sudden events like an automobile accident.
Okay.
So for this very large group of population of people, sometimes the guardianship is put in place on an emergency basis and might be a limited guardianship as opposed to a full guardianship, and might get to the point where it should be terminated. So this is the category that Britney Spears would fall in, right? She had a mental breakdown, and her father was appointed as guardian. So then you fast forward 18 years later, and she's been able to produce multiple albums, and she's been very successful in Las Vegas, and has been very appears to be competent. She's been a judge, on a television show. So you have somebody who is working and appears to be very competent, and then you question, well, how can she possibly be under a guardianship? It's considered a guardianship.
I was shocked. I couldn't believe it. Right.
But we only know what the media shows us, right?
Okay.
And I don't know all the details. I haven't looked at any of the court documents, but this Britney Spears, guardianship, it certainly has captivated everyone's attention, because you look at it and it really truly is a real life fairy tale. You have the Princess of Pop, who has everything going for her. She's got beauty, success, talent, all this going for her, yet she is under the control of her father. So it has caused miscommunication, misinformation out there. But again, people have to understand that each state is different, each case is different, and what happened in her particular circumstance, I don't know what her medical records show. Those are things that, of course, are going to be kept under seal and quiet and not produced. And she doesn't want, now that she's expressed that she no longer wants the the guardianship to continue.
Right.
She's entitled to have, her counsel and for the procedure going forward, but she's requesting not to have a health evaluation. Well, that's what controls a guardianship, right? Is an individual's health and their ability to make decisions for themselves.
How would a judge in that instance, and of course this is some speculation involved, obviously, it seems, just to a layperson, everyday person that I am, if the judge needs to have a full set of facts and I'm not willing to turn over vital health information, that seems like a pretty important component to my ability to make decisions to determine my future, no?
Absolutely. And I can tell you that in the state of Michigan, the probate judges here will require possibly independent medical examination.
You would think.
There's going to be a full, ability to have discovery. And most counsel will request mediation so that some agreement can be made amongst the parties. But also in the state of Michigan, the judges have to try to minimize the amount of control, because they want to maximize the individual's independence. So in the instance that a limited guardianship is appropriate, that's what the judge is supposed to order. So guardianships are not all or nothing. It can be tailored to the individual's needs. So, for instance, Britney's guardianship, well, I can't speak to California law, but if she were here in Michigan, the judge would be able to then say, well, Britney, you've been very successful. You've been able to deal with your own managers and the public, and you present yourself well. So we're going to allow you to have some control over your finances, over what you do daily, because I believe that she's under curfew and she's not able to do what she wants to do as far as leaving in cars. Well, I'm sure that some of that is her father's opinion about her safety. But I think the judge would have to look at all the facts and make a determination based on all those facts that must be presented in court.
I think it's an interesting fact that you've brought up, because it's something that I didn't really, and I doubt that I'm alone, which is that your idea of guardianship isn't necessarily a discrete on or off situation, that there are different grades in there that the judge has, or that motions can actually be filed where some subset of guardianship, if you will, is granted and other levels are not.
Absolutely. And diving into that a little bit more, that third group of people that we talked about, the 34% of people who have this sudden need to have a guardian because they have a sudden medical need, you're dealing with the population who have mental illness, people who have substance abuse. And again, the need might be temporary. So if somebody has an overdose, and I can think of a particular client, overdoses on a drug, and
Sure.
there's the parents immediately go to the court and they get emergency guardianship so they can control that individual's, their child's who's over the age of 18, their medical decisions and their care. Now, after that person recovers, maybe they go and have rehab, maybe they're going to get their life back together. So a permanent, long-term, full guardianship isn't necessary.
Right.
And some of the laws...
Go ahead. No, I was just wondering whether or not that's not determined in advance, though, right? In other words, that in your situation, the one that you described, there's an overdose or some situation which you believe to be temporary. Judge kind of understands it's going to be temporary and then grants it to a particular date, or it's just good until canceled, if you will.
It is usually good until a particular date, because when it's under an emergency, it is a temporary guardianship that is put in place, and then a hearing date is set. So then a hearing date is set, and the judge will ask the status of the individual and whether a permanent guardianship would be needed. The person who's petitioning can actually then request that it be a permanent guardianship and a full guardianship, or maybe it'll just be a limited guardianship. And I've been in some cases where the judges have a lot of discretion. So they can go ahead and they can say, well, we're going to review this again in 90 days.
Okay. So there can be time. So the judge could, in theory, set a date where, look, I need an update, and then reconvene. In the absence of it, it kind of ends. Is that the way that a temporary situation occurs, or is
yes, a temporary guardianship will end because what the person is given, the person who's appointed as guardian, are letters of guardianship, and the letters of guardianship have a specific date and they have a specific designation as to what they can do. It can be that they're just able to talk to the doctors and make sure that they can administer the medications, but they're not going to change an individual's residency. Okay.
And as far as you know from the facts that you've seen or read in the press and things like that, what's happened with Britney Spears? Or is it so different that it can't really be compared? I mean, we've talked from what you've said, and maybe this isn't true in California. Is it purely because state to state is this different, or the principle kind of stays the same across the state? And I know that individual states will have their own individual ways of approaching, but
I don't believe that, I think the reason what happened is Britney stated, I no longer want a conservatorship. She had said that she didn't know that she could end it. And one of the most important things that I stated in the process is that the person who is going to be under the guardianship receives personal service of this. So at the time that they receive it, they can object from the beginning. Okay. So from the onset, if they object, the court will either appoint them an attorney or, if they don't have one appointed, but the individual can hire their own attorney, but the court will appoint an attorney for them to represent them in this, in this whole hearing, in this whole process. Mm-hmm. So in the Britney situation, for whatever reason, she didn't realize that she could end the guardianship, and she changed counsel. And I guess it was with the change of counsel that she realized that, she can proceed with, if not terminating, but she could, maybe get a limited guardianship.
So there are still possibilities that, and of course, again, we're speculating, to a large degree, that even in the absence, I still find it like kind of hard to believe that, in the absence of medical records, you're the adjudicator trying to make a judgment here, how you'd be able to make any alterations really, other than what implied evidence from the fact that she's been able to perform in concert and be a judge on, TV shows and things like that. Is that enough? I don't know. Without a medical record, I don't know. I'm not sure.
I don't know what her legal counsel is preparing to present.
Sure.
But it is going to take a long time for this to play out.
It is. This seems like it's already been taking like years or something like that.
Things do take time. And one of the things that they're going to be looking into is, Britney is alleging that her father breached his fiduciary duties.
Sure.
And, there's a lot of
that you would suspect, right? I mean, immediately, fiduciary responsibility being breached by, conservatorship or guardianship, whoever has controlled the money.
Well, okay, so let's get to that. In the state of Michigan, the guardian must prepare an annual report, and that is reviewed by the judge. Okay, so the judge can either reappoint the guardian or that guardian can be removed. A conservator must prepare an annual accounting of all income receipts and all expenditures that have gone out. It must be to the penny. It must balance. And that is presented to the judge in a hearing. Some of the jurisdictions, some of the counties actually don't make you have a hearing if their analysts have reviewed the accounting and they balance and they find that there's sufficient proofs to what has been attached to the accounting, then you actually don't have a hearing. And the conservatorship's annual accounting is approved and the conservatorship continues. So under the Britney Spears case, I don't know what's been accounted for, what hasn't been accounted for. I don't know if what her father is claiming to be reasonable compensation is truly reasonable compensation for what he's doing. So those are the questions that are going to be under review. And just because you're dealing with millions of dollars, you're dealing with all these variable issues, it's going to take a while for them to go through the court process.
When that kind of thing happens, I mean, in the past, I've been asked by attorneys on when somebody wanted to end a marriage on, information about access to Medicare, et cetera, and, how you split up the costs and things like that. In your experience in Michigan, at any rate, to the degree that you can comment, are the judges equipped to, read the data? Somebody presents them a set of financial facts. Do they then go get an expert witness to testify or to examine that, to look through the documents to actually give an opinion on whether or not, yes, these documents look like they're in order, or is it just kind of anointed with holy water and on you go?
Oh, absolutely not anointing with holy water.
Okay.
Okay. So I've seen many judges that grill the attorney what is this, this lunch, this bar bill here? How is it that the conservator, I understand that they can have lunch when they're coming into town to take care of the individual, but a $50 bar bill is not appropriate. So the judges actually do pick through it. They also have, their own, court attorneys or their clerks that assist with the review of these accountings. So depending upon the court, there's different people who do it. I mean, like I said, some counties have what they call analysts. Sometimes it's the judge's clerk, but they are scrutinized.
So there is staffing in place at the court already with this specific set of information and skill set to be able to interpret whatever reports are delivered to them?
Absolutely, because all of this takes place in the probate court. So this is one of the specialties that the probate court handles. And if the handling attorney who's presenting this accounting can't answer the judge's questions, then the judge will not approve the accounting and maybe reset it for another hearing, allowing that individual to come forward with additional information or disallow the accounting. The accounting can be disallowed altogether.
Interesting. Okay, let's take a break from here, Kim, and we'll get back onto the next topics, all right? So Kim, describe this situation to me. Let's just say, for example, someone middle-aged gets in a car accident as incapacitated or can't make isn't in the condition to make a medical decision for themselves. That person's married. What happens?
Okay, that is a common misconception of married people, that they can speak for their spouse in making end-of-life decisions or even making just medical decisions. No one can speak for another person. So you actually have to have legal authority. There are two ways to have legal authority. You can have a healthcare power of attorney that is drafted at a time when the person has mental capacity. Or if somebody doesn't have that, then you have to go to the court and get a guardianship.
Let's just say, for example, somebody didn't plan ahead. They didn't come to Kim for, when they are able. Mm-hmm. And then they get in a situation. Now, all of a sudden, they can't make medical decisions. And then you need to have this emergency guardianship as the second of those two that you just described. Do I have it right?
Yes, Jay, you do.
Okay. And in that situation, how quickly can the decision be made, right? I mean, sometimes you need these medical healthcare decisions being made quickly, not after a month of planning, for example.
Right. So what happens is it's an emergency petition and the attorney walks right into the probate court with the petition that day and goes before the judge that day based on the fact that it is an emergency, that, actually end-of-life decisions, medical decisions must be made today.
Okay. So it can actually be expedited to that degree. Like there's not going to be some like huge waiting period. And I don't mean to be encouraging our audience to, not deal with it because then you'll just deal with it on an emergency basis later, but more that it is possible if put into that position to get an emergency guardianship if I've understood your comments correctly. Is that right?
That's right. But it does have to be a true emergency situation.
Okay. So now we've got this person back to the car accident victim. And now, for example, they're unmarried, but they have parents, for example. So now let's call them 30, 35 years old. What do the parents do?
The parents are frustrated because they want to be able to speak to the doctors and help make decisions. And I have a quick story. I'm an estate planning attorney. I do this for a living. My oldest ended up going off to Kalamazoo for her first year of college. And in the middle of winter, she got into an automobile accident. I got a phone call from her friends. So I drive white knuckled over to Kalamazoo, go to the hospital, and I'm told, nope, sorry, we can't give you any information. She's 18. no HIPAA, no powers of attorney, nothing put in place. So I had to wait, and it was very frustrating. So without powers of attorney put in place, no information is given to family members. And there is no authority to make medical decisions without a healthcare power of attorney. So a healthcare power of attorney, it's also called a patient advocate. A patient advocate can speak for somebody who's incapacitated to make medical decisions.
Nice.
And along with this, you can also have, if a person wants to make end-of-life decisions and put it in writing, they can specify whether or not they want to have a respirator, whether or not they want tube feeding, whether or not they want CPR. And as long as it's in writing and they appoint a person, to do this, that's who the doctors are going to be conferring with, and they're going to be looking at this document.
Always wondering about this document. Does it have to be certified by the court?
No, it's not presented to the court in any way.
I see. Okay.
It does have to be witnessed by two individuals who are not family members, who are not caregivers. There's actually a really long list of people who cannot be witnesses to this patient advocate. It cannot be the appointed patient advocate.
I got you. Okay. So what other challenges, generically speaking? So now we've got this, your daughter was 18 at the time, but if she's 27, right, quite a different set of problems and challenges. What are some of those from your experience in this type of situation?
Absolutely. So a lot of times people in that age group, well, we're finding out, employers don't really provide medical insurance any longer. And if individuals do not have the income available to them, they might not be insured. So a lot of people are on Medicaid. Some people are just uninsured altogether. And when people come across to me wondering what they're going to do, how are they going to be able to make sure that this individual is going to get the medical attention that they need, that's when I send them to you, Jay.
And, their paths are limited to some degree. I mean, it depends on the situation. I mean, first of all, if someone is 26 or older, they're not able to be under their parents' coverage. And actually even adding them is not that simple. So after the fact, much like in your practice, Kim, I always encourage persons to think of, how to get insurance, and especially with the Biden, what I call Biden care, meaning the Affordable Care Act enhanced version, if you will, as a response to COVID. The reality is those enrollment deadlines have, which are coming up, but have been expanded, and access to actual insurance, compliant health insurance has improved. I don't think there's any question about that. Medicaid, of course, is, an entirely different matter because of the fact that, that is a financial means-based test with, you're governed by state rules, and Medicaid is as well, meaning eligibility is not a federal decision. It's one made by different states. And, the reality is that the variance, the different outcomes in different locations, in different situations is all over the map, literally all over the map. But certainly if they don't have a job, it's been interesting because the government response to COVID has been so extreme that a lot of extra avenues that have been largely unknown are being uncovered now, meaning that persons who are unemployed for whatever reason at any point throughout this year, they have access to health insurance. So it's strange because, our example here of a car accident, it's not necessarily the fact that they're a victim of an accident which is creating their eligibility, but that it may be just a catalyst to were they properly informed before the accident? You see what I'm saying? And then this becomes the catalyst to, I need to find some extra facts. And then, many, many exceptions, can exist, largely that were either in place or as a result of the American Rescue Plan Act, which has, like I said, widely improved people's access to insurance. I guess for you more generally, as we back up, the law, let's just say, for example, this becomes permanent, a situation where the person cannot work, that is different because the person can, for example, apply for and possibly be accepted for a Social Security disability insurance.
Mm-hmm.
After that, there's Medicare eligibility prior to the age of 65. So, you can have situations where, like you mentioned, stroke, for example, incapacitating somebody from not only from making their own decisions, but also being able to not work for an extended period, then they can get eligible for Medicare, which opens up an entirely different pathway in terms of how they would pay for their healthcare costs.
Mm-hmm. Yeah, that's why the guardians, it's a very broad responsibility, an important responsibility. And based on all of those variables that you just talked about, somebody who's then thrusted into this position really needs to employ experts such as yourself, attorneys, to help them through the process. And a person's condition can change, and estate planning and healthcare coverage, all of that is fluid, right?
Yeah, absolutely. And I think that this goes back to, or comes back around to, what you do generally. During the break, you mentioned the fact that a lot of what we had talked about as far as these nuances of guardianship could have been avoided in advance. That's the case, is from what I understood. Is that right?
Right. So if something happens, if someone has the foresight to say they're going to go ahead and get their estate plan put in place, one of the most important documents with an estate plan isn't the will. Okay. It right. is the healthcare power of attorney. Who could make medical decisions for me if I become incapacitated? And also a general durable power of attorney. The general durable power of attorney, the person who's appointed the attorney, in fact, will be in charge of making financial and legal decisions for that individual. Now, the financial general durable power of attorney, that document can be effective immediately. So you don't have to prove incapacity to have somebody act as your attorney. In fact, under a general durable power of attorney, finances, you can go ahead and delegate that to someone. But your healthcare decisions, that is personal to you.
Sure.
That is not something someone can, make decisions for you if you have mental capacity. Okay. So in order to use the healthcare power of attorney, that person has to have the inability to speak and make sound decisions for themselves.
And if they're able to do so, then at that point, however, you would be able to not get around is the wrong, because it implies like you're trying to circumvent something, but you would prevent the controversies that, have affected Britney Spears at this time, or not. I'm not sure. It's not clear to me.
Okay. And that's a really good point, Jay. And I like the fact that you're going in that direction because, depending upon the individual, it does happen. There might be an individual who just isn't making good decisions for him or herself.
Right.
And a lot of times it's with an aging parent. They don't want to be in the nursing home. They want to go home, but it's not safe for them to be at home because they're going to fall and they're going to end up back in the hospital and, they're going to go back and forth. So even though someone's appointed as the healthcare power of attorney, the patient advocate, sometimes it is necessary to go to court at that time to get a guardianship so that they can then tell the individual, or show the individual, to show the doctors that that individual can no longer make their own medical decisions. And I am going to be speaking for him or her and watching out for his or her care and custody and well-being.
Normally when we think about estate planning, most people are kind of like wrap that into a time frame when they're considering retirement or, kind of preparing for retirement. Um, is that generally what you found? Is there any, how successful do you think that yourselves as attorneys in your niche practice, in your niche corner of the world, how effective do you think that you have been in communicating this to people in our age division, for example, and younger?
I wish I could get through to the people at our generation and younger, because I mean, everybody's just so busy, and it's something that they put off and put off and put off. Sure. But there are actually 2 points in time that people do consider estate planning. And yes, retirement age is certainly one of them. Mm-hmm. The other one is when individuals start a new family, and then they become concerned about if they end up passing away, having minor children, how will their minor children be cared for? And although we're really talking about adult guardianship, we have been talking about up to this point, there is the need sometimes for minor guardianships. So if mom and dad pass away, or if mom and dad are incapacitated, part of an estate plan, a person can appoint who they would want to be as guardian of their children.
It's an interesting point because, like I said, we're so accustomed, or certainly I am, as a Medicare person, Medicare, as this author and always making comments, those I get linked, but you're really saying that this is much broader, wider number of cases. It just so happens that this Britney Spears case has pushed this to the limelight, whether or not it's been that pleasant to read or not is that, it's kind of slightly different. So generally, if we go back to the retirement age persons, I see a lot of advertisements about the idea that, well, protect your assets, through estate planning. Mm-hmm. How are the rules from state to state? I've always been curious. Are the rules from state to state wildly different from one another?
Are you talking about just estate planning?
Yeah, in the sense that, certain elder law attorneys are out there stating in public, in advertisements, that they can shield assets, from these set of expenses from, nursing homes, for example.
Okay, so that specific question regarding Medicaid and nursing home costs, yes, the laws are different from state to state. Now, I know that some states have a higher income threshold. Okay. So, for instance, Florida, if you earn a certain income, then you're not going to be eligible. Here in the state of Michigan, the income threshold is whatever the monthly cost of care is at the nursing home. So if the nursing home is charging you $10,000 for private pay or $8,000 for private pay, most people who are going to be placed in a nursing home don't have $8,000 or $9,000 a month income.
Right.
Okay. So then really the focus becomes, you're not looking at income-based Medicaid, you're looking at, well, what is the threshold for being eligible, asset-wise? And, in Michigan, your assets, your countable assets are only at $2,000, and that number hasn't changed in decades. So it's a very, very low amount of money that an individual is able to keep. So a lot of people look to, well, what kind of strategies can be put in place to preserve assets? And there is a lot of information out there about trusts, but depending upon the kind of trust that you have, putting money aside into a trust that you have access to isn't going to work because it's still countable towards you. If you take money and you put it into a trust that you don't have access to, then that's considered a divestment. It means you've given your money away to another person. And the state of Michigan has a 5-year look-back period. So if you have the foresight of, maybe you've been diagnosed with a disease that you believe is going to be progressive, such as
degenerative over time, right?
Mm-hmm. So at the onset of the diagnosis, you may go ahead and do some planning to set the money aside into a trust that someone else is going to manage for you. And that way that those assets are protected. But then you have to look at well, what assets are you going to put in this trust? If they're qualified assets, if they're in an IRA, if they're your retirement accounts, putting them into a separate account, a separate trust, you're going to have a tax consequence.
Sure.
So you really need to be careful. You have to deal with somebody who is very qualified in this area of law to be able to do the planning. So every case is going to be different. There isn't a magic wand that you can wave and say, I'm going to protect all your assets from Medicaid. It is not just state by state driven. It is case by case driven on what a strategy might be.
And just for our listeners and, our audience, Kim pointed out a nuance that I've always pointed out on this channel, which is that you pointed out that moving the assets to one where they don't control kicks off a tax implication. And that's absolutely right. Meaning that, and so for persons who have an IRA or 401k, you're changing the owner. And the only way to change the owner is to first receive the assets to your own name. That's a tax event. And then move it to this other legal structure that Kim referred to. And so you can, Kim, you've not been here as I've been sitting here on my soapbox saying that we've got these topics that people like to keep in silos, but now you see immediately the interaction, because here a legal structure that you might recommend now all of a sudden may or may not work because of your investment strategy and the way that the assets are qualified or non-qualified, for example, in that instance. So you've got a number of layers to really consider when you're putting these different pieces into place. So I'm glad you've, interjected with this, whether you knew so. I didn't plant this with you, so, but certainly that is, definitely part of it. So from what I always wonder, because the countable asset question, excuse me, that the promises that we see or see on advertisements from attorneys, and you're an attorney, and there are advertisements from people who say they're Medicare experts. So I mean, we're all get lumped together at some level by something. What's Kim's personal reaction then when you see these types of advertising? Overly aggressive from Kim's point of view, or it's really there's a hook so somebody calls to lead them to potentially some better information? How do you personally kind of see that?
Well, I mean, I see, and I know a lot of attorneys that do that. I personally don't do that. I do more reactive planning, but I do try to educate people who, do have, change in life circumstances. Anytime that somebody has a change in life circumstance, they should be seeking out advice. And I do offer, free 1 hour, consultation to talk about what's happening in that individual's life and what they can do. So for instance, if somebody has this progressive disease, I would certainly look at their assets and discuss how to protect them. But to actually market, broadly to tell people that I can go ahead and shelter their assets for Medicaid, I personally don't do that.
Right. Let's go back to how people get a hold of you, Kim. I thank you so much for your time. We're almost out of it. How do people get a hold of you? I know that you've got a website and things like that. Why don't you tell us about it?
Sure. I have a website. You can reach me at Great Lakes Family Probate and Estates, and you can go ahead and give my office a call. We're at 888-554-5373.
I'll be sure to include that in the description, both in the podcast as well as in video form, so people will be able to get a hold of you. Did I miss something for this first conversation, Kim?
I don't think so, but you do have a certain hook there for elder law and talking about Medicaid planning. There's a lot that we can actually discuss. There's a lot of different strategies that are available.
Let's reconvene and talk about that at a future date.
All right. Sounds great. Thank you so much, Jay.
Thanks for being here on the Much More Than Medicare podcast and broadcast. Thanks, Kim.
Thank you. Bye-bye.